Welcome to Week 6, Workers' Compensation. One part of workers' compensation is the federal workers' compensation programs. The U.S. Department of Labor's Office of Workers' Compensation's programs administers programs that provide wage replacement benefits, medical treatment, vocational rehab, and other benefits to federal workers or eligible dependents who are injured at work or acquire an occupational disease. These four programs are Energy Employees Occupational Illness Compensation Programs, the Coal Mine Workers Compensation Program, the Federal Employees Compensation Program, and the Longshore and Harbor Workers Compensation Program. In the Federal Workers Compensation Program, which was enacted in 1908 and administered by the OWCP and provides workers' compensation coverage to all federal and postal workers throughout the world for employment-related injuries and occupational diseases. The benefits include wage replacement, payment for medical care, and where necessary, medical and vocational rehabilitation assistance in returning to work. The federal agencies reimburse FECA for workers' compensation expenses through an annual budget chargeback process, which transfers funds from a responsible federal agency's budget, which is the U.S. Postal Service, to DFEC. Now, under the state workers' compensation programs, the Worker Compensation Insurance provides weekly cash payments and reimburses healthcare costs for covered employees who develop a work-related illness or sustain an injury while on the job. It also provides payments to qualified dependents of a worker who dies from a compensable illness or injury. Now, state workers' compensation legislation resulted in the following three types of coverage, which is the State Insurance Fund, which is also called the State Compensation Fund. It's a quasi-public agency that provides workers' compensation insurance to private and public employers and acts as an agent in state workers' compensation cases, including state employees. Another is the self-insurance plans. Employers with sufficient capital to qualify can self-insure, which means they are required to set aside a state-mandated percentage of capital funds to cover medical expenses, wage compensation, and other benefits, which includes death benefits to an employee's dependents payable to employees who develop on-the-job illnesses and incur injuries. As far as eligibility for workers' compensation coverage, in a workers' compensation case, no one party is determined to be at fault, and the amount a claimant receives is not decreased by proof of carelessness nor increased by proof of employer's fault. A worker will lose the right to workers' compensation coverage if the injury resulted solely from intoxication from drugs or alcohol or from the intent to injure himself or someone else. To qualify for workers' compensation benefits, the employee must be injured while working within the scope of the job description, be injured while performing a service required by the employer, or develop a disorder that can be directly linked to employment, such as asbestos or mercury poisoning. Also, for eligibility for workers' compensation coverage, an on-the-job injury would include, for example, a medical assistant who is injured while picking up reports for the office at the local hospital, or a worker who is making a trip to the bank to deposit checks. These both qualify as job-related assignments. An employee sent to a workshop in another state who falls during the workshop would also be eligible for compensation, but not if she was injured while sightseeing. Clarification of workers' compensation cases. The injured employee's healthcare provider determines the extent of disability. Cash benefits are directly related to established disability classifications. Federal law mandates the following classifications of workers' compensation cases. The first one is medical treatment. Medical treatment claims are the easiest to process because they are filed for minor illnesses or injuries that are treated by a healthcare provider. Now, for temporary disability, these are claims that cover healthcare treatment for illnesses and injuries, as well as payment for lost wages. Now, for permanent disability, this refers to an ill or injured employee diminished capacity to return to work. In this case, a provider has determined that although the employee's illness or injury has stabilized, he or she has been permanently impaired, and the employee is therefore unable to return to the position held prior to the illness or injury. For vocational rehabilitation, these claims cover expenses for vocational retraining for both temporary and permanent disability cases. Vocational rehabilitation restrains an ill or injured employee so he or she can return to the workforce. However, although the employee may be incapable of resuming the position held prior to the injury or illness. For survivor benefits, these claims provide death benefits to eligible dependents, and these benefit amounts are calculated according to the employee's earning capacity at the time of the illness or injury. Now, when it comes to workers' compensation and managed care, both employees and employers have benefited from incorporating managed care into the workers' compensation programs, thereby improving the quality of medical benefits and services provided. For employers, managed care protects human resources and reduces the worker compensation's cost. Now, the first point of a workers' compensation's claim is the first report of injury form. And these forms are completed by the provider or the physician when the patient first seeks treatment for a work-related illness or injury. And this report must be completed in a quadruplicate with one copy distributed to the following parties. One will go to the State Workers' Compensation Board, another will go to the employer or the designated compensation payer, and then one would be for the ill or injury party's employer, and then another would be the patient's work-related injury chart. In following up with the first report of injury form, it does require some information that's not automatically furnished by a patient. When the patient tells you that this was a work-related injury, it would be necessary to obtain some additional information, and that is the name and address of the present employer, the immediate supervisor, the date and time of the accident or onset of the disease, or site where the injury occurred, and then the patient's description of the onset of disorder if the patient is claiming injury due to exposure to hazardous chemicals or compounds, and these should be included in the patient's description of the problem. Thank you.